logo. A logo can usually be protected not only by copyright, but also by trademark. So under the trademark law, once you use the logo in connection with your product or your service, you own that for the product or the service. But let's say you create a logo and you want to use it on, 20 different things. Stationery, clothing, mugs, in connection with a service where you're selling, or you have a retail store that you're selling some item. So in connection with all of those things, when you first use that logo in connection with that, you do own it for those products and services. But in the whole realm of things in the world, in the logo alone, you really don't own it in terms of the copyright until the ownership in that logo is transferred to you in writing.
And that could be something as a simple email or a letter from the person that created it for you?
I'm sorry, I didn't hear what you said. Could you repeat that?
Could that be something as simple as a letter or an email from the person that you had created for you?
Yes. You basically have them say that, they created it for you, that it belongs to you despite any payment that they might have received from you, and that the full rights in whatever they created is transferred to you as a certain date.
Wow, this is very interesting because, I've been reading some things online about copyright, trademarks and different things, and I know copywriting was always the most confusing because it seemed like there was such a gray area about when. Some of the things I read, it seemed like the issue was when something was, I guess, created and considered copywritten. But it's really interesting to know that even if you paid for something like a logo or a picture, that person has to transfer those rights to you in order for you to move forward and actually own it. And is that something new, or is that just more, I guess, as people get online more and more and get businesses set up and logos set up, that's more of becoming more of a front, and in front as a concern?
Well, I think people aren't aware of it. Even, photographers are probably more aware of it, again, because of the Internet, because there's more of an opportunity for people to copy things more easily and more readily. But, often graphic designers aren't even aware of this issue.
Okay.
And most graphic designers that I've met and encountered will freely transfer the rights to you because, they created it for you. They don't have any interest aside from, just doing the work for you. Sometimes you might give them an exception where you'll allow them, to display it in their portfolio. But they often aren't even aware of the issue.
But as a small business owner, or somebody who wants to become a small business owner, it really does behoove you to have some legal assistance like yourself to make sure that you're protected, because you don't want to be dealing with something after the fact. Right.
You want to protect your intellectual property as soon as the opportunity exists to do so. And if you have spent a lot of money or, a lot of time and effort in having a logo created for you, you don't want to be in the position of having to sue somebody for copyright infringement a year down the road when you haven't had the copyright registered. And the reason I'm saying this is not only because, like I said, if you register within 3 months after publication, then you get statutory damages and attorney's fees. But also, in order, like I said, to sue, you have to have the copyright registration. So your registration fees go from like $35 to, I think it's about $700 or $800. That's just the fees from the Copyright Office if you need an expedited registration in order to sue for copyright infringement. So you want to have all your ducks in a row, as soon as possible, so that if you do have to sue somebody for copyright infringement, you don't have to go through the expedited process, which is going to cost you, so much more than if you just registered it from the very beginning for that very nominal fee.
Yes, I would never thought that a copyright fee would start as little as $35. I guess that's something for more like a page or something small, not a book.
Are you still here?
Yes, I thought I lost you for a second, but
Yeah, I think we we did.
Oh, okay. Yeah, because it got real quiet real quick. Now, ebooks, are they something that you should consider copywriting if you're not going to share it online?
Well, I thought the whole purpose of an ebook was to share it online. And again, but if it isn't, again, from the moment that it was created, it is protected by copyright. Again, the issue becomes if someone, copies your material and you want to sue them for copyright infringement, then it has to be registered. But I would recommend to everyone, whatever it is that they want to claim copyright protection in, that they put the copyright notice on it, which is, again, the C in the lowercase, the business name or the owner's name, and the year of the creation. So that puts people on notice that you are claiming copyright. Again, even though the notice isn't there, it's still protected, but by putting the notice there, then you're telling people, don't copy this, or, you're going to be looking at a copyright infringement lawsuit.
Now, Lisa, if somebody's looking for an attorney to help them with that, is that something that, I know you can help them, but is that something that you're limited to working with people in your state? How does that work?
Okay, copyright protection is a federal protection, so you don't really need a lawyer in your state to do that.
Okay.
The same with trademark protection as well as patent protection. The time that you would need someone to be a lawyer in your state is if you were suing in state court for copyright infringement, which you probably wouldn't be 99% of the time. You would be in federal court if it was attached to a state claim. But in order, again, copyright law, trademark law, patent law are federal laws for the most part. And so if you get into an infringement situation and you're suing in state court, if I'm not admitted to the federal district court in your state court, I would need to associate with a lawyer within your state or get admitted by the court for the specific purpose of representing you in this one action, which happens quite frequently, actually.
Okay, so what people should look for is a person like yourself who has 30 years. I mean, I know everybody don't have 30 years, but have experience in this particular specialty. They don't have to be limited to someone that's local.
That's correct. I work with people all over the world. People who are coming to the United States to protect their intellectual property, and people from the United States who want their intellectual property protected outside the United States. I have a group of associates that I work with all over the world, that I worked with for many years that, help me. I'm not an expert by any means on the law of most other countries, so we go to the legal counsel in those countries, and then between the two of us, we work together to protect the client's interests.
And how would someone get in touch with you, Lisa, if they were interested in talking to you about getting some of their information and hopefully websites and their business, just to make sure that they have all their ducks in a row in the beginning?
You can reach me at my office number, which is 954-534-9419. And you can also go to my website, which is FloridaTMLaw.com.
And that's FloridaPALaw.com?
Florida TM is in trademark, T, capital M, law.com.
Great. Well, Lisa, I really appreciate it because I tell you that was one thing that even I was confused about. I mean, I've been looking at it for a year or two now, and I know that when people start out businesses, especially online, they, have this idea that they could just throw up a website and kind of get rolling, and then once they generate income or they get a couple months down the line, they'll be concerned about these kind of concerns. But it seemed to me that one part of your business plan should be having an attorney that can help you with copyright and trademark and protecting yourself from day one.
That's absolutely correct. I can't disagree with that. People often think that when they register their domain name or they get their corporate name from the state, that they're good to go. But those things, the domain name only protects the domain name itself, and you could still be infringing someone's trademark. For example, if I go to register Quaker Oats, spelled QUAKEROATES.com, and the real company has the registration, the domain name Quaker Oats, spelled OATS.com. Just because I got granted the domain name does not mean that the Quaker Oats company is not going to sue me for trademark infringement. The same thing for a company name, using that exact same example. Just because, let's say, the state of Indiana registers your name as the Quaker Oats, OATES company, does not mean that the Quaker Oats company, OATS, is not going to sue you for trademark infringement.
And those names we know Quaker Oats, but sometimes it could be a company that might be in India that you never heard of personally, but have trademark rights.
It could be, yes, but trademark rights are national rights. They're usually country by country. There are very few exceptions. For example, in South America, there's some treaties between the countries there that allow, rights from one country to the next. And the European Union has trademark rights, has a trademark registration covering all the countries in the European Union. But generally, you have to go country by country to protect your trademarks. And the United States is a different animal in that in the United States, your trademark rights come from use, not from registration. But almost all other countries in the world, your trademark rights come from registration. So it's important that if you think you're going to Japan to sell your product, that you get a trademark registration in Japan as soon as you can.
Okay, so I can copyright my name? Because I guess I never thought about copyright as far as a name of a business or a domain name. So
okay, copyright doesn't apply to names. Trademarks apply to names. And sometimes it's a confusing concept because sometimes there are trade names and there are trademarks. So if you're only using the trade name to refer to your company and, your website is the ABC, concrete manufacturing company, but you only use a logo and the brand of your concrete is the Wiki Wacky Concrete, and you only use the ABC Concrete Company, at the bottom to identify yourself, let's say, or contact us at the ABC Concrete Company, that may only be trade name use. But if your big banner at the top of your website is the ABC Concrete Company, we manufacture, we prepare concrete sidewalks and driveways and whatever, and somebody else is manufacturing concrete and they're the ABC Concrete giant, let's say, you could be infringing. So sometimes trade names can also be trademarks. Think of like IBM. IBM is the company name, but it's also the trademark for the products that they produce or used to produce, and it's also the service mark for the services they offered, let's say, for repairing their products.
Wow, okay. So, thank God for lawyers.
These concepts are, confusing. They're not always straightforward. So, again, it's always a good idea to talk to a lawyer at the beginning so that you get your ducks in a row, so you're prepared for what comes down the road, because you don't want to be behind the eight ball. You rather be in front of it and have your rights protected as soon as you can.
And Lisa, just for the people that may have not caught it a couple minutes ago, give out your website and your phone number one more time before we wrap up the show.
Okay. My phone number is 954-534-9419, and you can look at my website. It's Florida TM, T as in Tom, M as in Mary, law.com.
Well, thank you, Lisa, for taking out the time to explain to us the difference between trademark and copyright. And truthfully, I've learned a lot about copyright because that was something that was totally confusing. And I will have to go back to some things. The RS I'm not concerned about. They want you to make sure that you understand the LLC and the S chapter. But some of the other